Hello, everyone. We will now move on to the first session, Threading the Needle, Contracts and International Commercial Arbitration. This session will be moderated by Ms. Thethe Mokele. Ms. Mokele is a senior associate in the Pinsent Masons Johannesburg office. She advises employers, contractors, suppliers, and professionals in the construction industry on standard forms of contract, including FIDIC, NEC, JBCC, and various bespoke construction contracts. She also represents parties to construction contracts in dispute resolution procedures, including litigation, mediation, adjudication, and arbitration, with experience in various sectors such as road and railway transport, power, and infrastructure. Enjoy your session.
Thank you, Ms. Courtney, and thank you to the Asia International Arbitration Center Young Practitioners Group for having us. Good morning and good afternoon, depending on which part of the world you're in. My name is Thethe Mokele, and I sit in the Construction Advisory and Disputes team in Pinsent Masons. I'm pleased to be part of this session's esteemed panel, which I'm proud to introduce, made up of female practitioners from different parts of the world, especially during International Women's Month. In our session, we will be covering what constitutes a valid arbitration agreement and pitfalls to avoid, the procedural law which governs the arbitration, and lastly, the substantive law to adopt during the arbitration. We will have a Q&A session at the end, but please feel free to send through your questions in the Q&A box, and we'll try and get through as many of them in the time allocated to us at the end of the presentations. The first part of our presentation will be led by Anna Lipner, an English barrister who practices from 39 Essex Chambers in London. She is a commercial and chancery practitioner specializing in domestic and international commercial litigation and arbitration, banking and finance disputes, insolvency and company law matters, as well as civil fraud. Anna appears frequently before the English High Court and Court of Appeal and various domestic and international arbitral tribunals. In addition, Anna is on the Attorney General's panel of junior counsel to the Crown and is regularly instructed in disputes on behalf of the UK government. Anna will cover what constitutes a valid arbitration agreement with a focus on the provisions of the New York Convention and various pitfalls to avoid. Our second presenter is Kelly Ongri-Jen, an experienced litigator based in Kuala Lumpur with a varied portfolio in civil litigation with a focus in construction and engineering, energy and utilities, and oil and gas industries, both domestically and internationally. Kelly's experience extends to project advisory work, and she's one of the youngest candidates worldwide to complete and pass the accelerated route to fellowship in international arbitration and AIAC certification in adjudication course. Kelly will be giving a general overview of the law governing arbitration and its effect on the conduct of international arbitrations and the procedure to be followed. To end off our discussion will be Khushboo Shahdadpuri. Khushboo is a senior associate at Tamimi Company in Dubai. She is a dual qualified lawyer admitted to practice in Singapore and the state of New York. Her practice focuses on multi-jurisdictional litigation and international arbitration. She has represented conglomerates and state entities in a wide variety of disputes pertaining to infrastructure, construction, energy, oil, and gas projects, as well as shareholders' agreements under the major arbitral rules. She has also represented clients before the Singapore High Court and Court of Appeal, the DIFC courts, and the QFC courts. Khushboo has also worked at the Office of the Prosecutor at the United Nations International Criminal Tribunal for the former Yugoslavia in The Hague. As you can see, it is quite the panel that has been constituted, and I look forward to each of their presentations. To kickstart, I will now hand over to Anna, who will kickstart our discussion this morning.
Thank you very much, and good morning from London, everybody. The starting point in any contractual dispute that's referred to arbitration is the arbitration agreement itself. And I'm going to give you some headline points about what constitutes a valid arbitration agreement and what some of the pitfalls are to avoid. As we know, commercial arbitration is a contractual jurisdiction, which means that the genesis of any arbitration must be an agreement between the parties that they will refer the dispute to an arbitral tribunal rather than resorting to the courts. And that is your arbitration agreement. And when we're dealing with contractual disputes in particular, that arbitration agreement will usually be found within the contract itself. So, what requirements must an arbitration agreement satisfy in order to be valid? Well, the starting point is the Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 1959, commonly referred to as the New York Convention, which has been adopted by most countries. I think there are 166 states that are parties. Rules relating to the validity of the arbitration agreement are found in 3 key places in the New York Convention. Firstly, under Article 2.1 of the New York Convention, the contracting states undertake to recognise an arbitration agreement when the following requirements are complied with. Firstly, the agreement must be in writing. Secondly, it must deal with any existing or future disputes in connection with a defined legal relationship, whether contractual or not. And thirdly, it must concern a matter capable of settlement by arbitration. And that's important because there are some areas of law, like family law, that are generally reserved for domestic courts. So that's the first set of requirements for a valid arbitration agreement. Then under Article 2.3 of the New York Convention, the court of a contracting state, when seized of a matter in respect of which the parties have made an arbitration agreement, shall, at the request of one of the parties, refer the parties to arbitration, i.e. the courts will decline jurisdiction to hear the dispute themselves, unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. So under the English Arbitration Act, for example, if a party seeks to litigate a dispute that's subject to an arbitration agreement, the other party can apply to the court to stay the claim, meaning that no further action can be taken in the claim. And the court will do so as long as the arbitration agreement is not null and void, inoperative, or incapable of being performed. So that's the second requirement for a valid arbitration agreement. In addition, under Article 5 of the New York Convention, recognition and enforcement of an arbitral award can be refused on certain grounds relating to the validity of the arbitration agreement. And this is important because the chances are, if you're seeking an arbitral award in an international commercial dispute, you're going to want to be able to have the award recognised or enforced in other jurisdictions. A contracting state can refuse to recognise or enforce an award if the parties to the arbitration agreement did not have legal capacity under the law applicable to them, or the agreement is not valid under the law of the arbitration agreement, or if the parties haven't chosen the law of the arbitration agreement under the law of the seat of the arbitration. So determining which law applies to the arbitration clause is obviously very important for determining its validity. In relation to the validity rules at a domestic level, each jurisdiction obviously has its own rules, and so you'll need to look at the law of the contract or of the arbitration clause to see what that says. But the UNCITRAL Model Law on International Commercial Arbitration 1985 is relevant because it provides guidance for domestic arbitration laws. So in terms of the formal requirements or formalities for an arbitration clause, it's worth bearing the following matters in mind. Firstly, both the New York Convention and most domestic arbitration laws establish as a formal requirement that the arbitration agreement is in writing. And that differs to certainly the general common law position in relation to the formation of contracts, which is that an agreement can be concluded orally. That's not sufficient for an arbitration agreement. Under the New York Convention, the term agreement in writing shall include an arbitral clause in a contract or an arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. So it doesn't have to be a clause in the contract, although, as I said, it often will be. The arbitration agreement could, for example, be agreed in an exchange of correspondence. Most domestic arbitration laws take a broad view of what constitutes a written document. So it will encompass telexes, emails, and other modes of communication which generate a record. But there's some variation between national laws. So, for example, the Netherlands Arbitration Act 1986 requires that an arbitration agreement be proven by an instrument in writing expressly or impliedly accepted by the parties. English law, unsurprisingly, takes a very common law approach and says that there is an agreement in writing, even if it's made orally, but then evidenced in writing, or if the parties agree orally, but then refer to terms which are in writing. Swiss law similarly requires an agreement to be made in writing or by means of communication, which can be evidenced by text. But in contrast, in Paraguay, an arbitration clause is not operative until a submission agreement has been properly executed. So there's a variety of different ways in which national laws interpret the requirement for the arbitration clause to be in writing. In terms of the substantive requirements for a valid arbitration agreement, as I've said, Article 2.3 of the New York Convention provides that a court shall decline jurisdiction in the face of an arbitration agreement unless it's found to be null and void, inoperative, or incapable of being performed. And there are various ways in which an arbitration agreement might be found to be null, void, inoperative, or incapable of being performed, depending on the choice of law. Most obviously, a valid arbitration agreement must reflect the conscious, mutual, and free will of the parties to resort to arbitration and not to another means of dispute resolution, including the courts. So the consent of both parties to submit their dispute to arbitration is the cornerstone of the arbitral agreement. But in addition, the infringement of other rights, other rules, of contract law may also constitute a ground for invalidity of an arbitration agreement. So, for example, fraud, illegality, lack of certainty, or lack of capacity might, depending on the choice of law, constitute grounds for the arbitration agreement being rendered invalid. So you'll need to analyse the arbitration clause for compliance with the law of the contract, with the law of contract under the law governing the arbitration clause. Just to take an English example, in a case called Krupa and Benedetti and others from 2014, this is a commercial court decision, the arbitration clause stated, in the event of any dispute between the parties pursuant to this agreement, the parties will endeavour to first resolve the matter through Swiss arbitration. Should a resolution not be forthcoming, the English court shall have non-exclusive jurisdiction. And the English High Court held that the clause was not effective because it was merely an agreement to agree a form of arbitration and not a clear mandatory reference to arbitration. So just to identify a few pitfalls to avoid or to look out for. Firstly, you want to make sure that your arbitration clause is drafted sufficiently widely to capture disputes that might arise. So where the arbitration agreement covers all disputes arising out of or in connection with this contract, for example, so long as a claim is based on the existence of the contract, it will usually also cover claims in tort. So the breadth of the arbitration agreement is something that you want to be aware of. Secondly, it's important to know the validity requirements under the governing law and in absence of a choice of law under the law of the seat. So, for example, in Venezuela, Section 4 of the Commercial Arbitration Act 1998 states that where one of the parties to an arbitration agreement is a state entity, or an entity in which the state holds a stake of at least 50%, the arbitration agreement must be approved by the relevant minister. And similar provisions are found under Iranian law and Saudi Arabian law. So there are specific requirements under national laws that you need to be aware of. Next, check in advance that the subject matter of your dispute is capable of being arbitrated. And then finally, make sure your clause conforms to the general contractual law of the jurisdiction governing it. That's all I was going to say. Can I hand back to you, Thethe?
Thank you, Anna. Thank you. That was very useful. And as part of your presentation, you've highlighted, obviously, the importance of adhering to these requirements that parties must comply with in order to have a valid arbitration agreement. But in your experience, would you say you've had experience where generally those requirements have been complied with, but there's an issue with the wording of the clause itself where it's vague? So during the stay application, for example, you turn to the arbitration clause and it's actually not really clear what exactly the parties are going to be doing. And how have you resolved that, or how have you dealt with that as the barrister on brief?
I mean, I should say in general, I think that challenges to the validity of the arbitration clause are relatively uncommon in relation to, for example, disputes about choice of law. But I have come across cases where there has been a dispute. And for example, I did a Section 9 application, which is the type of application I was describing under the English Arbitration Act. Where one party is applying for a stay, and we were the party, the other side were applying for a stay, and we were saying the arbitration clause was insufficiently certain for it to be enforceable. Now, that was probably not the strongest way in which you could challenge an arbitration clause under English law, certainly, because there's a very high bar to meet to show that any contractual clause is void for lack of certainty. And actually we didn't succeed. But I think that in general, certainly the English courts are very keen to uphold bargains between commercial parties. And so if there is, if it appears that the parties did intend for a dispute to be subject to arbitration, then the court will usually try and find a way of interpreting the arbitration agreement so as to give effect to it. And I think probably for that reason, that kind of challenge is not actually that common.
Okay, thanks, Anna. Thank you for that. All right, I'll now hand over to Kelly for the second part of our presentation on the procedural law of the contract.
Thank you, Thethe. Thank you, Anna. Good afternoon from Malaysia, everyone. I'll be focusing on the procedural aspects and the legal framework governing the conduct of an arbitration, and also what are the considerations that parties usually take into account when choosing the seat of an arbitration. So an international arbitration usually involves two or more parties from different countries. And in that case, parties will usually prefer to have the arbitration in a place or country that's considered to be neutral. So what we mean by neutral is where none of the parties to an arbitration has a place of business or residence over there. So for example, if we have a dispute involving a Malaysian entity and a China entity, sometimes the parties may prefer to have the arbitration conducted in Singapore. And so the law of the place will also be known as the seat of the arbitration. So in this example, we are taking the Singaporean law as the law governing the arbitration, and Singapore will be the seat of the arbitration. This means that in practice, the law governing the arbitration will generally be different from the law that governs the substantive matters in dispute. So the law governing the contract itself and the disputes that have arisen from the contract. And if parties do not make an express choice of the place of arbitration in their arbitration clause, usually they will have the option to do that before the commencement of the arbitration by way of parties agreement, and failing which the choice will have to be made for them either by the arbitral tribunal itself or the designated arbitral institution. The UNCITRAL rules, for instance, state that unless parties have agreed upon the place where the arbitration is to be held, such place shall be determined by the arbitral tribunal, having regard to the circumstances of arbitration. And what we mean by the circumstances of the arbitration usually takes into account, for example, the time zones of the places where parties are located, where the arbitrators are located, the cost involved, and also convenience factor between the different locations. And because each country has their own set of laws governing the conduct of arbitration, we have the UN Citral Model Law, which acts as a baseline template for any state wishing to incorporate it into their law of arbitration. And because it is the model law across for international arbitrations, the provisions used are usually drawn in relatively broad terms. They do not have detailed procedural rules as to the actual conduct of the arbitration. For example, they do not stipulate the time period in which a party is supposed to submit the statement of claim, the statement of defense, or the order in which the witnesses are to be called, or the time allotted for examination of witnesses. These are usually left to either the parties' agreement or the directions of the arbitral tribunal. The model law also provides that the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings, and failing which, the arbitral tribunal will conduct the arbitration in such a manner that it considers appropriate. In order to determine how effective the conduct of an international arbitration is, we usually not only look at the procedural laws governing the arbitration, we also look at how do we go about enforcing the award, because if there are no provisions in the local legislation that helps to enforce the award, what parties may be left at the end of an arbitration is just a paper judgment. So one way of looking at it is we look at whether there are any provisions in local law for judicial assistance. Because even if the arbitrators have the power to order interim measures of protection, such as
Thank you all very much for the very informative session. We'll now have another break, and I will meet all of you here again at 8 p.m. for our last session of the day, which is a hot debate.
So it is necessary to turn to the local courts to help and enforce the arbitrator's directions. The next consideration is whether meetings and hearings have to be held at the seat of the arbitration. There is a Court of Appeal case which says that it may often be more convenient to hold meetings or hearings in a different country other than the seat of the arbitration. But this does not mean that the seat of the arbitration changes with each change of country where the meeting or the hearing is held. The legal place of arbitration remains the same, even if the physical place changes from time to time, unless parties, of course, agree later on to change the seat of arbitration. And because arbitrators and parties to an international arbitration come from many different countries, so it may not always be convenient for everyone to travel across the country or to a different country where the seat is for the purpose of just having a short meeting or an interlocutory hearing. So it may be expensive, it may be less expensive and easier to meet elsewhere. In recognition of this reality, Article 14 of the ICC Rules of Arbitration was amended to allow hearings and meetings to be held other than at the place of the seat of the arbitration. And this is also similar in Article 16 of the London Court of International Arbitration Rules, where the arbitral tribunal may choose to hold meetings or hearings at any convenient geographical place in its discretion, and if elsewhere other than the seat of the arbitration. The arbitration shall be treated as an arbitration conducted at the seat, and any award shall be deemed to be made at the seat of the arbitration for all purposes. I think this is especially significant in light of the recent events where COVID is rampant and parties are unable to travel. Usually parties are able to conduct meetings or hearings across Zoom, where physically parties are in different parts of the world, but the seat of the arbitration remains the same. And it's also important to determine where an award is made, because that ties into the recognition and enforcement of the award subsequently. Depending on the local jurisdiction and the local laws of the country, some of the validity of the award may be refused on the basis that the arbitration agreement itself is not valid under the law of the country where the award is made, or that the award itself has been set aside or suspended by the country, the country courts. So in this case, there are certain rules in place that parties may choose to adopt in order to make sure that the award remains valid at the end of the arbitration. For example, the ICC rules provide that an award is deemed to be made at the place of the seat of the arbitration and on the date stated in the award. So this is sensible because, for example, in an international arbitration, usually you have a panel of 3 arbitrators. So they may be located at different parts of the world with signatures rendered at different parts of the world. So it's important to make sure that it's an enforceable award, and the ICC rules help to deem the award being made at a certain location that's convenient for parties to enforce later on. And so the benefits of determining the seat of the arbitration early on, before a dispute even arises, is that it gives an established legal framework in case of disputes later down the line, because once parties are unable to see eye to eye with each other, it's difficult for parties to come to an agreement as to, let's agree to have this arbitrate in a very commercial manner, in a very friendly manner. So it's best if these terms are being laid out at the outset. The pitfalls to avoid is where you have to check whether the provisions of local law, whether there are any mandatory rules. For example, the award being rendered, does it require a physical signature on an original copy, or is an electronic signature sufficient for the purpose of enforcement? And also whether there's a defined period of time where the award has to be rendered in order for it to be valid. And in that case, not every country may be suitable for having and conducting an international commercial arbitration. So at the outset, parties are mindful to take a certain amount of time to do some forum shopping to see which are the best avenues for an international commercial arbitration to be conducted. That's all. I pass it back to Thethe.
Thank you, Kelly. That was quite insightful. We know that there are some clients that are very diligent and will come to us as their legal advisors to assist them in drafting the arbitration agreement and making sure that the seat as well as the governing law speak to each other. But there's instances where we only come in at the tail end and the parties have agreed these things prior to our involvement. Have you, in your experience, had instances where the governing law and the seat conflicted, and what were some practical ways that you dealt with that or advised the client, especially with regards to enforcement, like you highlighted?
Yes, I think at the outset, when it comes to the cost factor, it's easier to get both parties to agree to have the matter arbitrate at a lower cost. But when it comes to actual enforcement of, let's say, discovery of documents or production, then it's slightly more difficult because the other party is actively trying to obstruct the process. Then it's the die lies where it falls, and you'll have to see whether you're able to find a way to circumvent that in the event that happens. Yeah.
Okay. All right. Thank you. I will now hand over to Khushboo for the last part of the presentations before we just have a general discussion and head into the Q&A session.
Thank you, Thethe, and good afternoon to everyone. Let me just start by saying it's a real delight for me to be here today, albeit virtually, and many thanks to the AIAC Young Practitioners Group for putting together this really exciting conference. So just following on from the themes discussed by my co-panelists today, I will sort of touch on the substantive laws and the mandatory rules that apply in arbitration proceedings. I think the substantive laws is generally uncontroversial. It's the law governing the subject and the merits of the dispute. It's the underlying governing law of the contract that parties are usually free to agree on. And this principle is also enshrined within a number of different arbitral institutions. So the AIAC's rules, for instance, Article 35 provides that a tribunal is free to apply rules of law designated by the parties. The same for the LCI rules. Article 22.3 says the tribunal is to decide the parties' dispute in accordance with the laws chosen by the parties. And the ICC rules also say something similar. Where the parties have not agreed on their governing law, it's rare, but there are instances that these do happen. The tribunal will apply the rules of law that it deems to be appropriate. And that's really a discussion for another day. So we'll just leave that as it is. But it's worth bearing in mind that the substantive law of the parties' contract also governs the arbitration agreement. And this is really an important nuance because an arbitration clause is essentially an agreement within an agreement. So the agreement to arbitrate the parties' dispute sits within the overarching contract agreed between the parties. And I think Anna had touched on this earlier. So oftentimes in arbitration proceedings, parties challenge whether there was even a valid arbitration agreement to begin with. Many times these challenges are brought due to tactical considerations, so either to prolong the proceedings or to distract the claimant from the merits of the claims. These challenges are in the first instance decided by the tribunal. And in order for the tribunal to make a decision as to whether the parties had even validly entered into an agreement to arbitrate, they would have to sort of fall back to the substantive law governing the contract, which would also govern the arbitration agreement by default. In some cases, it's rare, but I have seen contracts where parties choose a different law that applies to the contract and a different law that applies to the arbitration agreement. But most often, they don't really make this distinction. And so the law that applies to the contract would apply also to the arbitration agreement. And that's what, as I was saying earlier, the tribunal would rely on as the basis to make their decision as to whether there's a valid agreement to arbitrate. Now, moving on slightly to the mandatory rules. So although the parties in an arbitration are generally free to choose their substantive law that will apply to their dispute, there are also mandatory rules that the parties cannot derogate from, contract around, or out of. And this may seem slightly contradictory or counterintuitive to what I've just said before with respect to parties having the freedom to choose their substantive laws. So I'll probably repeat what an eminent legal practitioner has said with respect to mandatory rules. And the way he described it is that mandatory rules are those that arise outside the contract, apply regardless of what the parties agree to, and are typically designed to protect public interests that the states will not allow the parties to waive. Generally speaking, arbitral rules also preserve the sacrosanctity of mandatory rules. So just to give you one example, the LCI rules Article 14.2 say the tribunal shall have the widest discretion to discharge their general duties subject to the mandatory provisions of any applicable law. So the next question I think would be, what are these mandatory rules and how they would apply to parties arbitration? And there are a number of different mandatory rules that could apply. So there are rules that apply depending on the party's chosen seat. And Kelly spoke about this. The seat is sort of the nationality of the arbitration, the legal place, and it's the laws of the seat govern the procedure of that arbitration. So there are certain clauses in arbitration laws of respective jurisdiction that may apply. There may be also certain statutes or legislation in the country of the chosen seat that would apply in an arbitration regardless of the party's contract. Now, these mandatory rules can affect the substance of a party's dispute, the merits of the claims and counterclaims. For instance, anti-corruption rules, competition rules. They may also result in parties' claims being considered non-arbitrable because of public policy considerations. So what this means is that the tribunal will be precluded from exercising jurisdiction over the subject matter of those disputes, even though the parties had agreed to arbitrate them. In other words, these types of disputes can only be heard before national courts in litigation rather than arbitration. Now, just to give you some example from my sort of experience in these sort of challenges or these sort of issues, in many jurisdictions in the Middle East, certain agency disputes cannot be arbitrated, even though the parties had agreed on arbitration clauses. And the underlying reason for this is that these countries want to protect agents from being unfairly terminated and want to afford them this protection, which they think they would deserve or they would get through the national litigation system and the national court system. So by ensuring that these disputes are heard before their own national judges, they can in a way control the decisions that are being issued to protect the rights of these agents. Now, I pause here slightly because I don't want to give you the impression that arbitration proceedings cannot necessarily protect these agents, and that is not at all true. But these sort of disputes that are considered or carved out of arbitration are very small type of agency disputes. For instance, they pertain to agency agreements where there's exclusivity or that's registered within the national systems of that country. And so generally, sometimes these states consider it just more sensible for them to take or exercise jurisdiction over these sort of disputes. Mandatory rules can also affect the procedural aspects of an arbitration. Just to give you an example, say if London is chosen as the seat of an arbitration, the UK Arbitration Act would apply to this arbitration. So Section 60 of the UK Arbitration Act actually says that a party's agreement as to payment of whole or part of the costs of an arbitration is only valid if it's made after the dispute has arisen and not before. So in other words, if there's an agreement made between the parties, before a dispute in question has even arisen as to how they would sort of divide or share the cost of the arbitration, this agreement will be invalid and parties won't be able to contract out of it because it's a mandatory rule and it applies based on the party's chosen seat of the arbitration. So some practical tips to bear in mind with this sort of issues is at the outset, just to think about the disputes that can and cannot be arbitrated in certain jurisdictions. There's also the importance of agreeing with the other party in an arbitration on provisions, or maybe asking or requesting the tribunal to make such provisions or direct them through the procedural orders if they don't apply in that certain jurisdictions. So in civil law jurisdictions, the concept of without prejudice doesn't exist in the same way as it does in common law jurisdictions. And to be able for the parties to hold on to these concepts and for these concepts to have teeth and ensure they're binding, they need to expressly agree between themselves, or they need to make a request for the tribunal to issue these sort of concepts or ensure they're binding through the procedural orders. So this can be done by way of terms of reference or by way of the respective procedural orders. There's also the importance of considering where a party might be attempting to enforce an award. And I think, again, Kelly touched on this. Nobody wants a paper judgment. End of the day, the whole point of going to arbitration, going through the whole procedures and getting a successful award is to ensure it's enforceable. The implications of enforcing in a particular jurisdictions need to be also considered very carefully, because enforcement may depend on compliance with local procedural laws and judgments. And again, just to give you another example, in Qatar for many, many years, enforcement of arbitral awards were denied if the awards were not issued in the name of the Emir, who is the ruler of Qatar, because this is the format of how judgments were issued by the national courts. Now, although this requirement is not needed or required under the New York Convention for Arbitration Awards, because the judgment existed and because there was no sort of decision by the highest court denying this sort of procedure, it just happened for many years. It just continued, and all the awards that were rendered or that were seated in Qatar had to be issued in the name of the Emir. If not, enforceability would be an issue. Now, this has changed very recently by a Court of Cassation judgment. But this case sort of illustrates the importance of considering the jurisdictions when award is to be potentially enforced. So if you're thinking about enforcement in countries such as China, India, or maybe even Brazil, you should just sort of consult litigation lawyers in those jurisdictions. Think about whether there are any procedural aspects that need to be complied with to ensure that the award is just foolproof and will be just safeguarded from any challenges later on. I want to touch very briefly on public policy before I end off my discussion. Two of the most notable limitations on party autonomy that result in challenges to arbitration are really arbitrability and public policy. And I think public policy is a really good example of something that's not defined, but yet, arbitration laws grapple with it because, as I said, it's not defined in the New York Convention nor in the model law. And there's no standard, so it's impossible to really provide a uniform and universally accepted definition of what constitutes public policy. But there are some benchmarks and some guides. So it's subjective depending on the jurisdiction, depending on the core values of a country's legal system or domestic standards of morality, justice, and public interest. And I think it's interesting because it's such an inherently flexible concept that's assessed on a case-to-case basis that sometimes you just never know what's going to come your way under the ambit of public policy. Some examples of cases that have been challenged on the concept or on considerations of public policy include where losses or reliefs that were issued or granted by the arbitral tribunal were contradictory to the national laws of that jurisdiction. Punitive damages, for instance, are not always accepted in all jurisdictions, unlike the common law, or where interests that were awarded by arbitral tribunals were excessive, or where there were instances of criminal offenses where there were bribery or corruptions. So these are some grounds under public policy that courts have used or relied on to challenge awards, and these are always something to bear in mind when they're thinking about enforcement. So I think that's it for me, and I'll hand it back to Thethe. Thank you.
Thanks, Khushboo. That was very, very insightful and very interesting. And I think it's a very interesting point that you raise on public policy, which tends to have an effect, like you say, on the autonomy of arbitrating parties and giving effect to not only the arbitration award itself and agreeing on issues that the parties might have agreed are arbitrable, but under public policy, this becomes an issue, but also in terms of enforcement. You could have a perfectly valid award that's been issued, but you struggle with enforceability because of public policy considerations. And I think you've given some very insightful examples, such as the one in Qatar, but I think maybe we could hand it over to Kelly and Anna to see if they've had experience with such, and if there's any specific public policy considerations in their jurisdictions that parties to international arbitration agreements should be cognizant of.
Anna, would you like to go first?
It's an interesting question. I'm struggling to think of anything under English law which wouldn't constitute, for example, illegality, but would render an award invalid on grounds of public policy. I'll come back.
I guess that's. No, sure. I guess that's also because of what you said earlier during your presentation, that the courts will generally give effect to, you know, what the parties have agreed to. So yeah, I guess it's a bit of a balancing act as well. It's not straightforward. Yeah, I get the difficulty that you might have with that. But I think in your particular jurisdiction, would there be specific issues relating to public policy, or generally not? So if parties have chosen the UK laws as the governing laws of the contract, would there be anything in terms of public policy that parties would need to be aware of? Not really, not other than your typical ones of fraud and
the reason I'm struggling with this is because I think a lot of the kind of compelling public policy considerations would already be enshrined in law, you know. So when you're thinking about things like corruption, for example, that would fall under the head of illegality. In addition to, I suppose, public policy, because the reason the legislation is there is for reasons of public policy. Yeah.
Maybe
so
let me just jump in here.
Yeah.
Just
sure,
to because it's a common law point that I suppose Anna was considering, and I mean something that has come up in Singapore in my early years of practice is the right to be heard. You know, that's something that it's part of natural justice, which is also on the flip side a part of public policy if you think about it. And that will be if a tribunal hasn't considered all the parties' evidence. You know, challenges are made on a party's right to be heard, which is part of it's sort of enshrined under arbitration, right? A party's right to be heard is something that it's there, you know, if there's a tribunal acts in a way that's contrary to the right to be heard, that's a challenge that could be made under public policy and or natural justice. And it's a high threshold to be met, no doubt. And this is probably why Anna seems hesitant on giving some examples. And every time we have cases where we bring these challenges in any jurisdiction, it's a really high bar to meet. And that's something worth bearing in mind, but that is not to say it hasn't been done before. You know, there's many instances, Singapore Court of Appeal or in cases I've done in Dubai and Qatar, where we have successfully challenged an arbitration award on the basis that the tribunal hasn't considered all the evidence properly, or the tribunal didn't sort of listen to a party's arguments, didn't want to award extra submissions that were requested by the party. So, and that's again, you mentioned this, Thethe, this is a very delicate balancing exercise, because as a tribunal, you have the discretion to control the proceedings, and yet parties also have the right to be heard. So you sort of have to balance this out to ensure that parties' right to be heard is respected and preserved, and yet as a tribunal, you maintain control of the proceedings in a way where it just doesn't go on endlessly and the party is just not trying to prolong them.
Okay, Kelly, I don't know if you have anything to add to that, just based on, any public policy considerations specific to your jurisdiction or what Khushboo has just touched on now.
So far, I haven't come across any public policy matters, but I think in Malaysia, once you have an arbitration award, there are steps that have to be taken after that. So depending on where it is being enforced, you may have to take the additional step of registering it as a court judgment before you're able to enforce that. So that's something that parties have to take into account in terms of the cost, and also whether they require local solicitors in order to have that registration done for them.
Okay. I think that is all in terms of our presentation and all the points that we wanted to cover, unless anyone has anything to add based on what either of the other panelists have touched on. I think I'll just open it up to Q&A. There is a question that's come in for Anna. Maybe we'll start with that, and then we'll see if there's any further questions that come up either in the chat, or please feel free to raise your hand and you can be unmuted to address your question to the panel. Anna, I don't know if you've been able to see the question in the panel, in the chat, sorry, regarding the arbitration agreement, and if an arbitration agreement from a specific contract is referred to a settlement agreement that arises from the contract dispute, does the arbitration agreement constitute multiple arbitration agreements or one arbitration agreement?
I'm not sure I completely understand the question. Sorry, I'm just having, if whoever asked that wants to explain it a little bit, that would be quite helpful.
Sure. I think Fawn, sorry, I hope I'm pronouncing your name properly. If you just unmute yourself maybe and just present your question orally, just so that we're all on the same page. I don't know if you're still on the session. I don't think the person is still here. I'm trying to send a message to say, please unmute yourself, but I'm not succeeding.
Does anyone else, maybe I'm just not understanding.
There's a new message. Let's see. Oh, he can't see an unmute button. I think maybe someone from the tech team would have to unmute him. Can we have some assistance, please? I think you're unmuted now from what it looks like on my screen.
Yes, hi, Anna.
Hi, hello.
Hi, everyone. Yes, very, very nice to meet you, and it's very nice and insightful conference that I've gained from you guys. So it's just a question regarding an arbitration agreement. So let's say if a contract have an arbitration agreement and the parties has resolved the particular disputes by referring, by coming up with a settlement agreement, which the settlement agreement referred to the arbitration agreement from the contract itself. Does that constitute multiple arbitration agreement or only one arbitration agreement? If you, yeah.
I see. I mean, it's quite, if you've got a settlement agreement that resolves the dispute, it would be quite unusual, I think, for the parties to then have an arbitration agreement in relation to the settlement, because the dispute's already been resolved. But if you did have an arbitration agreement in your settlement agreement, I suppose, for example, if there's a problem with carrying the settlement agreement into effect, then I think you would be looking to the arbitration agreement in the settlement agreement to resolve that kind of dispute. But if there were any outstanding issues under the contract itself which hadn't been resolved by settlement by agreement, then any disputes arising out of the contract would be subject to the arbitration agreement in the contract. So I think you probably do in that situation have multiple arbitration agreements which apply to different sets of disputes.
Yeah. All right. Thank you, Anna.
But obviously this is all very much in the abstract. So
yeah, it's just on the surface.
It will depend on what the agreements say.
Yeah.
And I suppose, Anna, just flowing from that, it would be similar to if, in terms of the settlement agreement, you're supposed to pay me X amount, and now I'm struggling to recover that settlement amount from you. If there's, some sort of dispute resolution mechanism in the settlement agreement, that would apply in terms of the settlement, but not necessarily the contract as a whole.
Exactly. Yeah.
Yeah.
And I think that really just goes to the kind of the scope of your arbitration agreement, and when you're construing the scope of the arbitration agreement, then you're looking at it very much in the same way as you would construe or interpret any other contractual clause. So what, on an objective view, what does this clause show that the parties intended?
Okay. Does that answer your question, Fan?
Yes, on the surface. Thanks. Thank you, Anna.
All right. Okay. I see Aziz has raised his hand. If the tech team would please unmute him.
Yeah, hi, everyone. Okay.
Hi.
Anna, when you answered that, you see, the point here was that basically there's a settlement agreement, because, let's say that parties had an arbitration agreement in their, as far as the dispute resolution mechanism for that particular dispute, but they have arrived at the settlement agreement. I thought the take would be that one can sue then on the settlement agreement, rather than, even if the settlement agreement provides for an arbitration agreement, or say clause there. But I think that can be sort of overlooked, can't it? Because if there's a settlement agreement, basically one would be able to sue on it and just go for Order 14, summary judgment proceedings based on the fact that there's a settlement agreement. Unless they want to actually say that the settlement agreement was procured through, say, fraud or whatever other circumstances in that sense, But I think if there's a settlement agreement, why do we have to go through the entire process of even creating, or rather going to arbitrate again on that itself?
Well, that's why I say I think it would be quite unusual for the parties to decide that disputes arising out of the settlement agreement would be arbitrable, because normally you would, as you say, you would then be looking to enforcement proceedings rather than the resolution of any kind of substantive legal dispute. So, I agree with you, but obviously I'm trying to kind of give an answer to a very abstract set of facts that are being put to me. But yeah, I agree. Normally, by the time you've arrived at settlement, then you would be looking to enforcement. Yeah.
All right. Thank you.
I don't know, Khushboo, Kelly, if you guys have anything to add on that. The whole settlement agreement issue and a separate arbitration clause, maybe some practical experience that you've had on that, because it seems to have taken a life on its own.
It is a really interesting question, and I did have a similar scenario once many years ago where we had an arbitration that was stayed, parties entered into a settlement agreement, which also surprisingly had a different arbitration clause as opposed to just going for a court national courts of any jurisdiction where enforcement was going to be or sort of initiated. So we had two arbitration clauses that were going on in parallel in many ways, and you know, because it was arbitration and a different set of rules, different seat, same laws, but still we couldn't sort of consolidate both the arbitrations. What ended up happening was that the respondents on the other side just kept trying to challenge the whole proceedings, and they managed to prolong it for at least 2 years because of what we call really poor drafting. And I think it goes back to the point that was made early on to ensure that when you're drafting an arbitration clause in a contract, to make sure you're thinking about enforceability, you're making sure you're thinking about reducing the risks of any sort of potential challenges and setting aside. That's something that most often parties, when they're drafting contracts, we call them midnight clause contracts. They're drafting it really late in the night. They're trying to finish it up, wrap up settlement. So these things get forgotten, but just to take a step back and always bear this in mind.
Kelly, anything from you?
Yeah, I think that usually what happens is that in the settlement agreement itself, there won't be any references to arbitrate anymore. So in the event where there's a breach of settlement agreement or parties are unable to come to ad idem on certain terms, then you will go for summary judgment or seek the court's clarification on just that particular point instead of going through the whole process. Potentially, I think the only scenario where there might be the insertion of an arbitration clause may be where a party who has agreed to a settlement tries to buy time and say that, oh, there is a dispute in the settlement agreement and I'll drag it on so that you've run through your limitation period. By the time you want to go to the courts, local courts, for any sort of resolution, then you're time barred from actually resorting to that.
And would that time bar apply in instances where, say, a construction contract, for example, has been completed and it's done, and a dispute arises 5 years later during a defects liability period or something? Would the arbitration clause generally, in your experience, based on the way it's drafted, survive the lapsing or the coming to end of a contract, or is your experience different? And I think, Khushboo, you could probably speak onto that as well.
I think for latent defects, there is an amendment to the local limitation law where it extends that to 15 years from the time of discovery. So if it's something that is only discovered way later, at least parties are able to, whether they go for arbitration or go for court proceedings to resolve that. So it's only for latent defects where they have this avenue. The rest, generally, it's only 6 years of limitation.
Okay. Khushboo, anything to add on that?
Yeah, no, I agree with what Kelly says. I think usually limitation periods, obviously they're subjective to different jurisdictions, but I think there's a subjective and an objective element. So where there's fraud, corruption, or what Kelly mentioned, the whole latent defects period, that's subjective as to when parties have noticed it. But generally speaking, I think it's pretty straightforward. If you miss the 5, 6, or 10 years, you know, there's no avenues to sort of argue or claw back to unless you have already initiated some sort of proceedings and then you stay it or it's suspended.
Okay. I don't know if there's any further questions from the attendees for the panelists. I guess not. I don't know if you guys want to have some closing remarks or if we should just close it off. And yeah, it's been a great session. Thank you all for your contributions and your presentations. I'm sure the attendees have found it very useful. Any closing comments, Anna, Kelly, Khushboo?
So sorry, I can go first, and then you guys can chime in whenever necessary. Maybe just to give you some sort of the closing remarks, I'll draw back on my experiences in arbitration proceedings, and that's generally what I specialize in more than litigation these days. And I can tell you in arbitration, though, the challenges that we see in arbitration nowadays for technical reasons, as I mentioned earlier, They are increasing in numbers, especially in the Middle East. We see challenges to the validity of arbitration agreements. We see challenges to the jurisdiction of the arbitral tribunals increasingly in all our cases. And I think that boils down to many times the poor drafting, or just not realizing that each jurisdiction has different nuances that need to be borne in mind when thinking about validity of arbitration agreement. Just to give you some examples, in the UAE, the party that signs an arbitration agreement needs to have a special authority to do this. If the company didn't give that person signing the arbitration agreement this special authority, that's a really good and strong grounds to set aside the arbitration on the basis that the parties didn't agree to it because the person didn't have a capacity to. We don't see these challenges much in common law jurisdictions, but we see it so much in the jurisdiction that I'm practicing it because it's in the law. It's so clearly put. There's so many cases on it, but most people don't even realize it because they don't think about the jurisdiction that where they are sort of arbitrating and where they're going to be looking at enforcement. And that's always so important. Enforcement is something that should be borne in mind right from the outset when you are sort of arbitrating the dispute.
Thanks, Khushboo.
Maybe I could just say something about what parties can do when they're faced with a questions to do with the validity of the arbitral agreement. So I think one of the things you have to think about quite carefully is how you're going to deal with it if you're faced with an arbitration where you say that the arbitration agreement is not valid, or there's a kind of a jurisdictional issue. And there are various options that you can take. So you can go to the courts and get an anti-suit injunction to prevent the arbitration from going ahead. I think that's probably best reserved for where you've got a real slam dunk point and you're pretty confident that you're going to succeed. You can bring a jurisdictional challenge before the arbitral tribunal and ask them to decide the question of whether they have jurisdiction to hear the dispute or not. Or further down the line, once the award has been obtained, you can then challenge attempts to have the award recognised or enforced, and that's probably a subject for a whole different discussion. But I think it's important to bear in mind when you're thinking about these issues what the practical implications are in terms of resisting the arbitration. So that's all I wanted to add.
Thanks, Anna.
Yeah, perhaps I'll just chime in for my closing remarks. I think that another issue that I frequently face in Malaysia is where when does the cause of action arise, and at what point do you stop claiming for it? So, for example, the time stops when you issue either a commencement request to arbitrate the matter or a notice of arbitration. So in the case where a project is ongoing, you may have to look at whether the institutional rules allow for consolidation of arbitration so that you can start another matter, but the issues get heard together, because frequently at the point where you issue a notice of arbitration, a subsequent cause of action may not have crystallized yet. And in order to prevent duplicity of arbitrations, it may be useful to look into whether there is a measure for consolidation.
Thanks, Kelly. I see there's a message that's come in on the chat. I don't know if this is something that you guys are prepared to deal with now, but I just thought I'd bring it to your attention. They've just raised something on challenges to arbitral awards on the grounds of different laws in your respective jurisdictions. I think we have touched on that, though. I think that was even part of some of the closing arguments that we've had. I don't know if that's a point to be developed further, but I think we have touched on it at a very high level on the challenges to the arbitral awards. I don't know, how do you guys feel about that? Is that something that there's anything further to add, or at the level that we've prepared for this session, is that something that's been dealt with? I think I'll take it that we have touched on it at a very high level. Obviously, if you have specific things that you would want to raise relating to that or have a more direct kind of dialogue on that, you're definitely free to get in touch with one of the speakers and send them an email. But I think if you guys are happy to wrap off the session, I think we can do that. Thank you to all the attendees for attending, and we'll hand it over back to the technical team and the coordinator.